Hi, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today I wanted to talk about depositions and give you some deposition tips so you could be a rock star in your deposition. In New York, depositions are called examinations before trial, and I did a video where I talked about all of the questions that defense lawyers ask plaintiffs in personal injury depositions. And that video is known as super depositions. And it has me in a little Superman cape. So take a look at that one if you want like a full outline of all deposition questions. But in this video, I actually want to go through a deposition that happened yesterday of a plaintiff where I sat and I defended the deposition. I was present at the deposition. It was done in my office over Zoom. The client was at his home using a laptop, and the defense lawyer was in his office in Manhattan asking the questions, and we were all doing it by Zoom. So I have my notes from that deposition, and I'll go through it, but I wanted to first explain that the important thing for a plaintiff's lawyer to do before a deposition is to meet with his or her client at least 2 or 3 times and do a thorough prep. Like we did 2 preps with this particular client, and each prep was over an hour. You really need to spend time and prep a client. The first prep should be more answering the client's questions and making sure the client is calm and not nervous about having to give a deposition, because clients are not lawyers, right? Clients are people that get into serious accidents like trip and fall, car crash, whatever it is. They don't know about how the law works or about how lawyers with like 10, 20 years experience ask or frame questions, right? So it's important to just put them at ease about the process, answer their questions, make sure that they understand everything, right? How everything works. Usually the defense lawyer will be asking questions. You have to answer verbally as opposed to nodding or shaking your head. And a court reporter will type everything up, and then you'll get a transcript. And some depositions are even video recorded, so then you'll have the actual video and you can play the video. So anyway, so this was the deposition yesterday. So it was my client. He was involved in a car crash, and the defense lawyer actually spent 5 hours and 11 minutes, because I timed it, in this deposition. The most they could spend is 7 hours. So this was pretty close. And he just kind of was using, I think, an outline, because he was going through, and a lot of the outline and the questions he was asking is exactly the same questions that are in that super depositions video I did earlier. And that's a long video, about 40 minutes. That's why I said that's a really good resource to go back and look at. But so, you know, he just went through the clients, obviously their name, have they been known by any other name, are they on any medication, any alcohol, have they had their deposition taken before, did they review anything before their deposition, and then a little bit of a history of their residence, and then they basically go through their date of birth, their social security number, where they were born, their height and weight, and whether the height and weight is, whether the weight has changed since the accident. Sometimes people gain weight because they can't do physical activity. And so things like that. And then they go into doctors and some medical treatment, like seeing certain doctors. And you know, it depends on the lawyer's style. Some lawyers will start with the crash and say like, you were involved in an accident. This lawyer actually didn't. This lawyer started talking about just medical treatment, and even going back to like 2020, which was way before the crash, and going through some medical treatment and the history. And then, you know, also prescription medication, things like that, just basically doing a history. And then if they find any providers that are relevant to the injury sustained in the car accident that they don't already have authorizations for, what they do is they say, we are now requesting authorizations for these doctors, like this hospital, this doctor, and we're going to send them this authorization, and we want to get the records directly from each doctor. The idea that I wanted to talk about was that it's almost like a war of attrition. They ask you a lot of questions that you would think are irrelevant, but sometimes you could object and get them stricken or say that they're objectionable, but there really isn't a judge at a deposition. So if you object, but the defense attorney says, no, that's a proper question, the only remedy is to call the judge. And the judge is not going to answer the phone and be available right away. They're probably, on a trial or doing something else. So then you might not even get a judge. And then, that might delay the deposition. So instead of 5 hours, it'll be like 7 hours, because you're spending time getting a ruling. So a lot of times it's good to work things out if you can. And, most lawyers know what's permissible and what's not. This lawyer didn't really do anything out of the ordinary, but it was a long deposition. And I think the reason they try to do that is because they want to wear you down. And they ask you a lot of these things about like your treatment history, this and that. But then at the very end, when the deposition is about to end, like maybe two or the final question in the entire 5 hour and 11-minute deposition, the lawyer asks, oh, what were some of the things that you were able to do before the crash that you cannot do now? And see, the reason they do it so late in the game is because they know that at that point you want to be done with it, so you're not going to say a lot. Because if you say a lot, right, if you remember everything, and we prepped with this client, we talked about, hey, why don't we do a day in the life type video? Like, for example, I woke up, I didn't sleep well because I'm in pain. I get out of bed, it's hard for me to even move, but I go to the shower. I try to take a shower, but it's hard for me to bend down or wash myself because I'm in pain. I get out of the shower, I want to bend down, put on my socks, I can't do it, right? And then just keep going, like going up and down stairs, lifting up in a shelf to get a coffee cup, and go through a typical day in your life. And so, but that was like the final question. So the client did a good job on that. He answered it, but he didn't go into great detail of his entire day, visualizing his entire day, because he was tired by then. And the defense lawyers know that. So that's like a trick. It's almost like a war of attrition. But there is something known as an errata. So what happens is you get the transcript in about 60 days. And when you get that transcript, you could make any changes or amendments or additions. So you could say, look, it was 5 hours in, I didn't remember this, but also I had trouble sleeping, I had trouble standing, walking, and all these examples that we talked about. So you could add to the deposition. Changing it is a little bit harder because when you change it, they could read both the original answer as well as the amended answer. So they read both, and you have to explain the reason for the change. But adding to it, I think, is okay. So then going through it, the next thing they asked was about orthopedic doctors for accidents. And I think what they're really trying to get at is whether the client had any treatment for orthopedic injuries before this accident. And then they can go into, your educational background, whether you have any training for specific jobs, how your employment was affected, how much time you missed from work, whether you're claiming lost wages, your job duties, whether you're receiving any type of Social Security disability or any type of disability, time missed from work, and whether the time missed from work was because of the crash, because you could be missing time from work for other reasons, right? And then they go into the doctors and what the doctors did for you, like the chiropractic, the physical therapy, whether you had any prior accidents, not necessarily only accidents, but whether you had any prior injuries to the same or similar body parts as what you're claiming in this case, because they want to know about whether you had any acupuncture treatment, whether you had any chiropractic treatment, because that could be relevant if you already had chiropractic treatment, let's say for your back, and then you injure your back in this crash, but you already had an injury. So they want to get those records. They want to try to say that it's not from this crash, it's from having it 2 years earlier. And then they can, of course, ask you about your marriage status, about the marriage, about your children, whether you have any children. This particular client, they asked him about also convictions. They could ask if you have any criminal history, and they could also ask if you have any past accidents, and they go into details on those. Now, with the criminal history, they can't really get into too much detail, but just whether, if it was a felony, they could ask what was the criminal disposition, what happened, and you just have to be honest about that. And with the prior accidents, they usually do something known as an ISO search. It's an internet search, insurance search. So what that will have is it'll have every claim. So for example, they asked my client about something that happened with his car right near his house in 2012, but it wasn't an accident. In 2012, we had Sandy, a big major hurricane, and his car it was parked. He wasn't even in it. It just got flooded. So maybe he made a claim to get some compensation, but what does that have to do with it, right? So you have to be, careful with that. You could let them ask in discovery, because this is deposition, right? It's known as discovery. You could let them discover whatever's relevant, but then if the case were to go to trial, that would be something that would not be admissible evidence because it's irrelevant. And so then they go to the date of the incident, what happened, and they just ask about how the crash happened. This particular crash was a rear-end crash, and where the property damage was. They could show photos of the damage to the vehicle, various doctors, what the doctors did for you. Basically, they ask, why did you go to this doctor? Who referred you, if anyone? And then, like, what did you complain of to this doctor, and what did the doctor do for you? And sometimes people remember, sometimes people won't remember the dates, but you know, the dates are in the medical records, so it's not a huge deal. But I do like to make almost like a little timeline of all the medical treatment. I think that's very helpful. Yeah, and that's basically about it. So then he went through, after all that medical treatment, he went back to the prior accidents and went through all the prior accidents in that claim search. And then only after the prior accidents, the final question was, the two questions were, number one, what are some of the things that you were able to do before that you could no longer do at all? And then the follow-up question is, what are some of the things that you were able to do before that you can still do, but not as well as you could do them before the crash? So, you know, I think those two questions are the ones where you want to, as a plaintiff, just give long answers, like really explain how it affected your life, how it is, if it's a serious life-changing forever injury, explain how, right? Explain how it affected the people you love, what you love to do, and who you love, and the relationships. And I even had like a 13-page checklist of different types of activities, you know, like Thanksgiving, Christmas, birthdays, you know, things like chopping, cutting, cooking, grocery shopping. You know, the more examples you give, the better. If you have any stories you could think of how the injury has affected your life, and telling a story either of yourself or of yourself and your friends or your family, your loved ones, that's very powerful too. And so those two questions, I think, is where the plaintiff should just talk, right? Like, talk as much as possible. All the other questions, like, you know, what color was the car? Blue, that's it, right? You don't want to say any more. Blue, and it had 4 wheels, but it's not responsive to the question. The question was, what was the color of the car, right? So all the other questions you just want to answer and take your time, but, you know, answer quickly. And those two questions about your injuries or damages, that's where you want to be able to speak more. Okay, so I hope this was helpful. Let us know what questions you have, and I hope you do a great job at your deposition.